for us, right from day one, we believe the Attorney General had a good case. And so after the prima facie case was determined, we were very positive that the trial was going to go on smoothly. However, when the prima facie case was determined, NAM1 challenged the ruling of the court at the Court of Appeal, and that was refused. And satisfied with the ruling from the Court of Appeal, he went further to the Supreme Court here. And we've been here for the past almost 1 year, and today the law lords have refused his application because he sought the court to give him a special leave so that they will halt the trial at the High Court. But today the court said no. And so what it means, our understanding is that the trial at the High Court can continue. And so today we also told that they will file their reasons on the 17th of this month. We shall go back to the High Court as was determined the last time on the 16th.
Phoenix Media. Now, Ayisha, you Men's Gold Ghana Limited. Sa company we yes establish and I say about Oman Ghana mu has say a year 2017. Na 2017 no eba ye no na chese omo ye nkrofobia omo ayo omo se fesika beji sika ye wo premium ye wo gold silver ne ade wo sika ba ne abo ho ama bosumi bi ne ade a na Men's Gold Ghana Limited no a problem no eba ye ebra na ye se omo askane amanfo ewo oman Ghana mu say problem ni nyina e hyase a year on the 7th of September 2018. Na ebeye kese pa on the 8th of January 2020 and also 2019. Na ye nyina ye nim se Men's Gold Ghana Limited no na openya ono eye ne dia no eye na Appiah Mensah a dodo na friend NAM1 wono ena na chese oye company no CEO a oda no na after say ni company no e collapse ye no ekoba say eye court here and there any adia na court no akọ asem no so ama yedi asem no abua NAM1 for ema still na yante ase eko appeal court any idea na ene de dwe no aya se NAM1 beche na Appiah Mensah ekopie mu ewo eye high court say nka ebeya court enhwe na the trials na omo pese omo eye no omo nye no appeals court wa nenso no ene de dwe enkra yensa aka ene se NAM1 meche na Appiah Mensah ekopie mu ho no eye decision ana se impokra na application or the command court no abo atuegu omo say on the 16th of December next week ya no omo share ne trials no enso ase ewo ho no na eye owura Frederick Forsen wono ene eye kasamafo ede ema NAM1 eye victims no wakasa ede afa court decision ana ruling na omo ruling against eye nana Appiah Mensah NAM1 ene de dwe ewo court no ho no wakasa ede afa ho na enigye a wonani age wakyerem enso ede ama oman Ghana de ntia nani age after the court ebo NAM1 eye ne appeal no anase na application no etugu ye no eye owura Frederick Forsen a wono eye kasamafo ede ema eye NAM1 eye clients no anase customers na yeji omusika omonsa anko musika no wakasa acheche mu imema mekasa anye wano yenko na yenkonkotie ensam a owura ne ede etudwa after the court e chance ene de dwe e kan sansem no ede efa ehun.
So the Supreme Court today handled two important things. One, a review application by the Attorney General with respect to decision as far as the Dubois case is concerned, and also an appeal ruling on the NAM1 case. Before we get to that of Dubois, I must say that NAM1 came to the Supreme Court appealing the decision of the High Court, asking him to open his case, and the decision of the Court of Appeal affirming that same decision. The Supreme Court has quashed his application seeking to review or reverse the decision of the High Court and that of the Court of Appeal. We have with us Frederick Forsen, a long-time spokesperson for the aggrieved customers of Men's Gold. Today, when you were coming to court, what essentially was your hope, and will you say that that has been met?
Yeah, for us, right from day one, we believe the Attorney General had a good case, and so after the prima facie case was determined, we were very positive that the trial was going to go on smoothly. However, when the prima facie case was determined, NAM1 challenged the ruling of the court at the Court of Appeal, and that was refused. And satisfied with the ruling from the Court of Appeal, he went further to the Supreme Court here. And we've been here for the past almost 1 year, and today the law lords have refused his application because he sought the court to give him a special leave so that they will halt the trial at the High Court. But today the court said no. And so what it means, our understanding is that the trial at the High Court can continue. And so today we also told that they will file their reasons on the 17th of this month. We shall go back to the High Court as was determined the last time on the 16th of this month, which is next week. So we are very happy and we appreciate what the court has done, just that it has kept long.
Do you get the sense that his appeal on the decision of the Court of Appeal has been decided upon, or is just an application to stay proceedings as matters go on at the Supreme Court that has been decided?
From our understanding, I think he filed 2 applications. One of them was the former appeal. I think what he brought here was that he wanted the court to stay pending appeal, and the High Court refused it. Then he went to the Court of Appeal, and the Court of Appeal also refused it. In fact, at the last one of the settings, even at the Supreme Court, the court said he should go back and continue with the trial whilst they come up with their ruling. And so this is about the 3rd time we have had 2 previous adjournments, and so this is the final day that the court has formally refused his application, meaning that the trial at the High Court can go ahead.
So what you understand is that it as the trial will go on at the High Court. Do you also get the understanding that you also have to come here again for the substantive appeal?
I'm not sure. Per the ruling today, it means it's over here, except maybe he want to take another decision. That is up to him and his lawyers. But for us and for our understanding, what happened here means that the trial court now can go ahead with the case.
It's been
and so he can open his defense, because at the last sitting the judge directed him that when we go on the 16th, he should be prepared to mount the witness box and open his defense.
It's been how many years now? Since 2018.
I'm telling you.
How has your membership been like, and what has been the ordeal of a number of people whose monies were locked up with Mensah?
We have gone through a lot, Hanson. It's almost 8 years now, 7 years. I have spent 7 productive years of my lifetime fighting this cause as the leader and the convener of this group. And we have buried more than 244 members. And on the issue of the situation, the condition of our customers, we are being tired of discussing them. Debt, harassment, adversity, poverty, broken homes, shattered dreams, destroyed businesses, and the rest of them. So it's not been easy. All that we are looking up to is that the trial should speed up. I remember when we started, before the prima facie case was determined, we were almost going on a daily basis. And so we pray the courts that now that the Supreme Court has given the go-ahead, we should resume that daily trial, so that at least we can come to some finality. Because even this, the case moved to the High Court in 2023, and here we are in 2025. The year is almost dying. So we would pray, we want to use these platforms to pray that the court will resume that daily trial, so that we shall have some finality and conclusions to this matter, because people are really suffering.
I know you've also been pushing on the side of government to come to your aid with respect to what they usually do for the banks. to at least come and pay the investors whose money have been locked up in Men's Gold. How far have your negotiations with government gone?
Yes, the last time in July, there was a meeting chaired by His Excellency the President himself, and we have also met the Attorney General. Now, what is at stake is we are waiting for the appointment of a receiver, and when that one is done, at least it will make the assurance double sure that government is committed. Whilst at that, we have also appealed to the government to consider sort of a bailout for us while the trial is going on. So we are looking forward for some of these things. Today I just had a short chat with the Deputy Attorney General, and we expect to go further with other discussions to see how quickly the receiver will be appointed, because that will mark the official acceptance or acknowledgement of the government of the issues involved in the main good customers.
So when next are you to go to the High Court?
On the 16th of December, which is next week, we are going back to the High Court at 9:30 a.m.
So thank you very much. That is Frederick Forsen. He is spokesperson for the Men's Good customers. He says that the ruling from the Supreme Court today paves the way for trial to continue at the High Court, where Appiah Mensah, also known as NAM1, is expected to open his defense. The case relates to an order by the Securities and Exchange Commission in 2018 to order a closure of Men's Gold Ghana Limited. A number of customers who had deposited money with Men's Gold Ghana Limited in the form of purchasing gold from a sister company of Men's Gold Ghana Limited had their thousands of Ghana cedis in investments locked up, and from 2018 till date, most of them have not been able to retrieve their investments. There have been series of protests and petitions, and they've also followed keenly with a criminal trial, hoping that at least some justice will be done to them, and they are asking the government to come in their aid to appoint a receivership for Men's Gold Ghana Limited, so that at the end of the day they can be paid their dividends, as they describe it, as well as their investments that have been locked up in Men's Gold Ghana Limited. Now, as part from the issue relating to Appiah Mensah, there was the case with respect to Addo, the former boss of the National Signals Bureau. If you would remember, Addo, together with his wife, have been on trial for alleged acts of causing financial loss to the state, stealing and using public office for profit, as well as money laundering. The case has been ongoing at the High Court, where they are still within the case management conference process, where the state is disclosing to the accused persons documents and potential evidence that will be relied upon in prosecuting the matter. At the High Court, the lawyers for Addo and his wife, led by Samuel Atachian, applied to the court for further disclosures to say that apart from the documents that had been supplied to them by the prosecution, there are certain other documents that they would need to make their defense. The High Court denied that plea. Based on that, they appealed, and also they came to the Court of Appeal arguing that the judge presiding over that matter has shown some form of bias and should be prohibited. And as part of the Supreme Court pronouncing on that application, the Supreme Court dismissed their application, asking for the judge to be prohibited from further considering the matter. But the Supreme Court went on further to make a pronouncement on what disclosures or what law should govern further disclosures. The judicial system uses what is called the practice direction from the Chief Justice, and in this practice direction, it is given that to justify further disclosures, the matters you are asking for must be in the possession of the prosecution, here that is the Aegis Department, and also must be relevant. The Supreme Court, in addressing the issues as brought to it by the accused person, that is Kwabena Duboahen and his wife, indicated that the matter of relevance cannot be considered at pre-trial stage, and relevance relates to the probative value of a certain material fact and how it would yield the court in deciding a matter. And so if any court is deciding on the issue as far as further disclosures is concerned, it should be materials that are in the possession of the Attorney General's Department, that is the prosecution, which are material or in connection with the case at hand. The Office of the Attorney General, having reviewed the ruling of the Supreme Court, and according to the Deputy Attorney General, upon consultation with various stakeholders in the security and investigative space, they felt that that lower burden of, or their understanding was that the ruling of the court created a lower burden where accused persons and their lawyers will only have to show that a matter or a material is in possession of the prosecution for further disclosures to be allowed. In their view, that is not good for Ghana's criminal jurisprudence, and so they invoked the review jurisdiction of the Supreme Court, asking the Supreme Court to review its decision and restate in the practice direction that to prove or to make a case for further disclosures, then you need to prove that the materials are in the hands of the prosecution and also relevant. Appiah disagreed with them, noting that the burden to even invoke the review jurisdiction of the Supreme Court have not been met in this particular instance, and as a result of that, the case should be dismissed. The Supreme Court, upon listening to the parties, set January 14, 2026 to deliver its ruling on the matter.
Very well, Hansen. So did we see Aduboahen in court himself? Were his lawyers present in this matter? Appiah, was he there himself? And regarding this matter, then it will have no business to do with the initial accused person who is now going to be to testify for the prosecution.
No, it has nothing to do with Mildred Donko, the third accused person, who we are told has been charges have been dropped against and will be called as a prosecution witness. Aduboahen was in court. His wife, Angela, was also in court, as well as their lawyer, Appiah, who made arguments against the position as espoused by the Attorney General. After court proceedings, we spoke to Samuel Appiah, who says that the current ruling or decision of the court is good for our criminal jurisprudence, because then it prevents situations where prosecution would decide to present evidence that is only relevant to them and keep evidence that they deem not relevant to them. And he says that the court saying that any material that is connected to the case should be served on the accused person at the time of disclosures is good to help at least espouse and uphold the principle of presumption of innocence until proven guilty.
Well, Hansen, so this January 14 date, what implications does it have on the original case being prosecuted by the AG And the ruling that will come on the 14th, what will it mean for that same case?
Well, this is more a matter of enriching Ghana's constitutional jurisprudence and also setting a pathway for future cases. Mind you, the main case was actually won by the Attorney General. Appiah, that is lawyer for Edubuahin, actually lost the application. But the Attorney General says, in respect of the criminal jurisprudence of Ghana, even though the Office of the Attorney General won the application at the Supreme Court, it's important that they apply for the review jurisdiction of the Supreme Court to partially review that aspect. So they are looking into the future. If the status quo remains, and on January 14, if the Supreme Court comes out to say that wrong with its decision and that remains the law, then what it means is that at the time of disclosures, where prosecution is giving out the materials and potential evidence to accused persons, then the only thing that should be considered is that are the materials in the possession of the prosecution, and are they in any way connected to the case? If they are indeed connected to the case and they are with the accused, they are with the prosecution, then there's a responsibility on the Attorney General or the prosecutor in the matter to give the documents to the accused person. However, if on January 14 the review bench of the Supreme Court decide to change the position as espoused by the ordinary bench, then perhaps they may decide to reinstate the issue of relevance, meaning that you would have to prove a threshold that the documents you are asking for are not only with prosecution but are also relevant to the case. The Attorney General's Department, represented by the Deputy Attorney General, argued also that even if it is not relevance, there should be some adjective or phrase that increases the threshold beyond just the material in the possession with the accused, with the prosecution, to something that would be of relevant fact or of relevance to the case in question. And he argues that at this point there should be a distinction between relevance in the technical sense and relevance in the ordinary sense.
Beryl Hansen, thank you so much, and we look forward to updates and subsequent reports that you'll be filing in our subsequent bulletins here on Channel 1 Television. Hansen Agyapong is our court correspondent, bringing us up to speed regarding two separate cases, one involving Appiah Mensah, also known as NAM1, and a review application he sought at the Supreme Court, which application we understand has been quashed, and so the High Court case can't continue. The second one had to do with also a review application by the former Signals Bureau boss, Kwabena Edubuahin. We understand ruling will be given on January the 14th, and so we are waiting to see the outcome of that. So, Chris.
I was away any and sama a Frederick Forsen, one a spokesperson, Edema NAM1, Nase Pokran, Edema men's good customers are or Moho Ekoka a Dremono. Ena yete in kase odi monchiremu edi emanti say trials no e hwase meche nana Appiah Mensah ne trials no e hwase next week 16th of December ye na on a trials no e hwase ti no after bibia no na se ebubo ne dia na either say otua amanfo sika momo ana say oko jail and so eho enum Phoenix Media. Message also subscribe to your YouTube channel na Facebook like video. Edi amami share ma foforo nya bi hwe na FIFA comment bra comment section. Yakram.